So we think that the first thing we should sort of acknowledge in this debate is that this is not about like whether countries should be sticking to centuries old practices, right? Like this is about whether keeping the constitution as a set of norms, not the like document itself, up to date is best done by a rewriting or reinterpretation. And we're going to propose that sort of making these constitutional amendments is a preferable option because it's more democratic and it actually can reflect sort of the sign of the times and what most people want, and this is what we should be following. So if we think about like, as a set of norms, not that like it's an unelected body, like it's not elected by the population. They are usually selected. The Supreme Court justices are usually selected by other judges amongst themselves in some countries, or the presidents, right? So if they are the ones who are sort of reinterpreting the constitution, we can see that this is this can be undemocratic, and it can like even in some cases they can sort of, if the president is the one who is nominating these judges, right? I have to see the POIs. So if the president is sort of the one who's nominating the members of the judiciary, we can see that they have sort of, if they have more room to sort of interpret the constitution to their liking, there is a higher chance that like whoever is in power at the time, the individual has more sway on how the constitution is interpreted, because he can like elect someone, a smaller pool of people who nominates the judiciary. We can see that sort of the interpretations that they have, if they have more sway in how they are interpreting the document, do not necessarily reflect the views of the population. And we do generally believe that sort of the constitution should be interpreted in a way that reflects what most of the population agrees to. And how is this done on our side when we have these originalist judges? We think that when it is considered appropriate, these constitutional amendments will be made through elected bodies. For example, in the US, they can be made like through like state legislators. And for example, in Finland, they can be made like through two like subsequent parliaments. So it's not like so we think that this is far more democratic, and we have like a higher likelihood of like actually reflecting the sort of views of the population and making appropriate changes. Because even if we have judges who reinterpret the things, we can see that not everything can be like reinterpreted, right? So we think that it is more preferable if we make these sort of updates and amendments through democratically elected bodies that actually reflect what the people want at that time. So we think that this is how we sort of keep things up to date, and not through like unelected judiciaries who are just interpreting the documentations. So I can take OO now.
State constitutions are deliberately extraordinarily difficult to modify. They're deliberately anti-democratic because they're meant to guarantee things that are above politics. In that context, when something comes to a judge's desk that is based on a law that is maybe 300 years old and well out of step with modern values, why do you think in that setting they've got an obligation to go against what is probably much closer to the will of the people?
Well, we think that when we have originalist judges, we think that then when we have these sort of outdated paragraphs of like things in the constitution, that they have duty to sort of amend those instead of trying to reinterpret them like desperately. So we think that isn't a problem. So we think that sort of So we think that sort of the biggest trade-off in this debate isn't like whether the amendments will be made, right? We think that those amendments will be made if the judges don't have the freedom to interpret the Constitution as they please. And we think that sort of the trade-off is like mainly between the speed of the change. Like if the amendments are made democratically, it can be slower. Like we concede to that, but or do we sort of make them through the judiciary? But we think that even if the change is slower, we think that it's better to make it like through democratic bodies, because the judiciary by nature is fundamentally unaccountable, and we don't think that this is good in a democratic society, right? So whether so we think that really we're not like ruling out changing things or sort of amending or sort of rewriting even like larger parts of the Constitution. We think that like different size amendments can require different processes. So smaller things can be, even though they're done through democratic bodies, they can be done in a more speedy fashion. But we think that generally in a democratic society, we shouldn't have this unaccountable, unelected body who is making these reinterpretations that touch the lives of so many people, because they can't be held accountable. They can be elected, put forward by like a leader of that time that maybe is only serving his own interest, and therefore you should propose things.
I'd like to thank the speaker for that fine speech. I hadn't realized this room is being streamed. So hello, everybody. If anyone doesn't consent, maybe say now, because I realized that we were asked for consent in the middle of a speech. So everyone okay? Cool. I'd like to thank the speaker for that fine speech, and I welcome the leader of opposition. Here.
Can you hear me? It's kind of odd that in order to want to reflect the views that we currently hold, opening government solution is to revert back to an archaic understanding of the Constitution and go through a set of amendments that they haven't explained will be expedient in order to get to a contemporary understanding. And the alternative that opening opposition intuitively gives you is the legal understanding that we have now, which is where judges are entitled to have a more modern and contemporary interpretation of the laws that are put in front of them. And that's what we propose. I want to do two things in this speech. I want to explain what a good legal system actually constitutes. Then I'm going to explain why the system that opening government proposes fails on a moral level. I think intuitively a good legal system ought to do two things. The first thing that it should do is that it should be fair in the sense that it grants minorities rights and women rights, etc. And secondly, it should be representative of contemporary values in that society. And the reason why that's particularly important is because it ensures legitimacy to that government and that state, and it needs to reflect the views and values of the society in that point in time. So why does originalism not then achieve this? For three reasons here. The first reason is that originalism necessarily uses a historical snapshot of values then as opposed to now, which means that to the extent to which it is good for a legal system to capture contemporary values, intrinsically this does not fulfill that. And I know the mechanism that opening government gives us is constitutional amendments. I'll get to that in a second. But if we even operate on the premise that it takes some time for those amendments to occur, the initial understanding of that law itself is archaic and is one that completely fails on a principle level. The second thing is that there is no justification as to why an originalist intention is best, which is to say that it is morally arbitrary as to what the white dude that was writing this thing was thinking as he wrote it, in that it does not symbolize any moral objective good. It does not have any particular importance that's enshrined within it. So we question the legitimacy of this on an intrinsic level, I suppose. And the third thing is that the intentionality of the author themselves is extremely difficult to extract, and it creates a lot of unnecessary abstraction or obfuscation within the legal system that should be there. The alternative that we have is that courts are embedded in values that they have now, and they're applied. Courts see constitutions that have values that are embedded within them, and then apply these to a modern context. Importantly, the values that we are talking about are the ones that are made most explicit. That is to say that things like, for example, we grant rights to all men, in an originalist understanding, would be one that grants rights to people who were conceived of men, to the extent to which African-American people perhaps weren't conceived of being people. It means that rights wouldn't go to them. Whereas now what happens is when you see all men, you have an understanding that all men entitles a large group of people that was initially originally intended. So that was what we wanted, and we were happy to do that. Why does this system fail then on a moral level, and why do we like to come out of that? Understand that constitutions can do two things. The first thing is that they can override legislature, and the second thing is that they're extraordinarily difficult to change. And I think this is problematic for a lot of their case, insofar as in the US, for example, despite there being popular support for several bits of constitutional amendment, no constitutional amendment has been passed in 50 years. But even if it is really easy to pass it, like in this abstract world that opening government has given us, that is still problematic for them, because it means that every time a new judge comes in, they have the capacity to revert or change the way that constitution is interpreted, such that it is more in line with that political stance. So regardless of whether you buy it is extremely difficult, which is the empiric reality, or whether you buy that it is as plausible as open government sets it out to be, that is still problematic. Let's talk about why the system fails now. The first thing to say is constitutions written in, the constitution itself was written in a milieu where certain rights weren't even conceived of yet. Which is to say that that context is a context uniquely that was very, very patriarchal, far more so than now, and was very, very white suprematic. Which is to say that rights of people like trans people or gay people wasn't a consideration that they had. It was something that they didn't even think about at that point in time. And that's important because it means that the beliefs that are enshrined within that constitution are unlikely to be particularly good from an originalist understanding. Because it shows that the laws that end up passing are not laws that seek to protect the rights of people that weren't even conceived of people at that point in time. So an example of this, for example, would be the right to privacy, right? Which is to say that in an originalist conception of this would not grant abortion to women because women's rights were not seen as something that was worthwhile or even legitimate at that point in time. The contemporary understanding obviously recognizes that moral values have evolved over a period of time such that we are now more morally conscientious than in a way that we weren't before. And that's really good. The second thing to note is that constitutions are not written prospectively, which is to say that constitutions understand what is the status quo at that point in time, not what changes in the future. So an example of this is the way that globalization has emerged in a way that no one in the 1700s could have predicted. So at that point in time, the set of norms that were existent were xenophobic and ones that, were particularly distasteful and distrusting of foreigners. So it means that to the extent to which that value has changed, but that value has changed over time, but it was not respected by the people that were writing that constitution at that point in time, it means that there is absolutely no relevance to the way that law should operate in today's society. Before I go on to my third point, I want to take a point of information from closing up. Do they have
closing? Yeah, okay, so can you maybe give me an example of what a widespread consensus of a contemporary value is?
Yeah, sure. Basically, when you refer to all people, you refer to people, including people who might not have been conceived initially as people. So all men would entail women, trans people, gay people, etc. Whereas an originalist interpretation strictly makes it such that it is only people that white man who was writing the constitution at that point in time deemed to be people. The third thing is that this creates needless ambiguity within the legal system, which is to say that this creates a lack of clarity insofar as it is extremely difficult to extrapolate the original intention of the Constitution. And I think a good intuition is to note that we had a 10-minute Q&A as to what this topic meant before we even came into prep. And the reason for that is because it is extremely unclear as to what original intention is. And the outcome of that is twofold. The first thing is that this privileges people who are the most wealthy, insofar as
they have access to the best lawyers such that they are able to have their interpretation carry more weight than another interpretation, perhaps, because the lack of clarity in the original intention means that that can be changed in a way that's bad. The second thing is that this creates a disengagement from the legal system. Minorities to the extent to which they do not believe their legal rights are actually enshrined within the Constitution, to the extent to which people are looking at an originalist interpretation as opposed to a contemporary one. This is morally arbitrary and ludicrous. We were proud to oppose.
I would like to thank the speaker for that fine speech, and I welcome the Deputy Prime Minister. Hear, hear.
Wait a second, let me just set up the timer. And I presume I'm coming through hearing-wise. Brilliant. Honourable Speaker, okay, let's just be extraordinarily clear here. We do not believe that on our side of the House, we're going to be spending an awful lot of time reading into the intentions of a document that is 300 years old. Why? Because those intentions will very clearly and very tangibly be out of date. The Constitution, as currently written in most countries, read literally, is nonsense. Therefore, we have to have progressively greater interpretation, specifically because judges are willing to do that reinterpretation to keep it up to date. Now, we believe that this form of keeping up to date is just fundamentally flawed because judges are old, wealthy lawyers, and you end up with rules that look like they've been written by old, wealthy lawyers. And we don't think we can change the type of people in the Supreme Court drastically, because as the arbiter of last resort, they must be the people who are the best at interpreting law, the most senior lawyers in the country. This underpins the entire authority of the lower courts, etc. So we don't think we can make the Supreme Court significantly more representative. This means that the Supreme Court is structurally a very poor body to consider what is up to date or what is the current will of the people, just because by definition, they have to be the best legal scholars around, and those are not an especially representative group, nor will they ever be. So we believe that on our side of the House, legislature works fundamentally differently because of the additional political pressure formed by the fact that the judges will literally not reinterpret anything. This means you can no longer blame the judges for the constitutional decisions that exist in the country. That means that there's no degree to which you can detach yourself from, you talked about, this 300-year law, the OO threat on a 300-year law being applied, and this is very clearly against the sense of justice in the people or whatever. On their side of the House, if this kind of a decision is made, the people will assume that there is some kind of a reason for it or whatever. But on our side of it, it's very clear that this is the fault of the politicians at the moment, because nobody did anything, because this law was allowed to be there, because constitutions are clearly just much more intelligible for people, because they are less old, because they are structurally have to be less old, because we are no longer updating them through reinterpretation. We are exclusively updating them through rewriting. So why can the legislature not just step in where this sort of structural misrepresentation is causing issues, right? Why can't the legislature just then, push an amendment where these old judges are doing something that's clearly wrong? Well, one, judges' decisions are generally respected, and where the judges have the authority to reinterpret the constitutions, many people will just assume that they're doing so for good reasons, that they're doing so taking in due account of public opinion or whatever, as OO has kind of run that case, right? This is something that people, broadly speaking, believe, even though this is structurally not true. Two, in a society where changing the constitution is a taboo, they mentioned in the US there has not been a constitutional amendment for half a century, right? Gathering the momentum to do so is extraordinarily hard, both in terms of it just being a political project that seems implausible, and two, because the actual rules involving the changing of constitution can be maintained to be so extraordinarily difficult. We'll talk about that in just a second. So then, on our side of the House, why can the legislature on our side keep up with the change in constitution? So first of all, as I've mentioned, the kind of idea where the threat of these sort of rulings that are very clearly unjust is very clear, and it is the fault of the politicians, there is much more political pressure to change the constitution, because there is no other way. This is literally the only way in which we are going to be able to do something. Compared to the status quo where the judges make that decision, the politicians would generally sort of blame the judiciary, at least the people will blame it. It's more muddled, right? Two, questions which are not actually extremely important to the makeup of the nation are less likely to be maintained within the constitution in the first place, right? So in a situation where where issues where people's views generally change more quickly, such as social policy, etc., we are like abortion rights or whatever, are more likely to be moved into ordinary legislation at the point at which politicians realize that it is in terms of their political survival extremely important that their party can maintain a public touch with it or whatever, that they can have the legal instruments in which to make the legislation such that their supporters are likely to support them, right? So therefore we think that they're likely to adapt. Alternatively, constitutional change can simply be made less arduous where you're not making major changes. For example, in Finland, we have multiple ways to change the constitution, depending on the exact nature of the change. And this is partly because the Supreme Court is, broadly speaking, originalist, right? We have to make smaller changes much more frequently here. Consequently, we've made those smaller changes much more easy to make. So therefore, we don't think it is in this sort of way, in a way, implausible for a legislature to keep up with popular demand. They talk about, kind of snapshot versus the continuous thing. Like, okay, sure, we accept that on our side of the house, we're always going to have a snapshot of the current will. But that's the case with ordinary legislation, right? It's always going to be a snapshot of the opinion of the current parliament, and I think that's just fair in representative democracy. If the constitution is changed every 4 years, we don't think that's a massive issue, then we are lagging between 0 to 4 years behind the popular will. Compare this to the status quo, where where evolutionarist judges are doing this interpretation, are doing this keeping up, they're likely to be lagging the majority of the population by 10, 20, 30 years, simply because they're, broadly speaking, going to be 60 years or older, right? So therefore we think even though we know they might be trailing continuously but much further back, because the people making the interpretation are going to be are structurally old and structurally misrepresentative, versus on our side we have snapshots, but these snapshots are updated, one, much more frequently, and two, by people who are structurally trying to respond to the needs of the people directly, rather than making these sort of philosophical arguments and having this sort of making this sort of philosophical argument of what is best for the nation. We think it's just simply better, especially when it comes to social questions, etc. On our side, these decisions are purely made by the legislature, which again happens only where the blame cannot be kind of balanced between the judiciary and the legislature, where the responsibility for keeping the constitution up to date is solely at the feet of the legislature. That means that they have the full power to do so. That means it cannot be taboo to change things, because as said, it talks about the idea that the originalist interpretation of the constitution is likely to lead to outrageous decisions. Well, when outrageous decisions can only be reversed by the legislature, you obviously get a political pressure in any kind of a democratic country through the legislature to do that, because that is the obvious and the only mechanism of change. So therefore, kind of to wrap this up very clear, we believe that snapshots by a representative body done fairly frequently are significantly better than a continuous reinterpretation by a structurally unrepresentative group of people that they have on the side of the opening opposition. For all these reasons, I am very proud to propose.
I would like to thank the speaker for that fine speech, and I welcome the Deputy Leader of Opposition. Hear, hear.
Can I be heard? The opening government is saying that originalist judges will lead to enormous screw-ups that hurt people's quality of life in a way that generates the political will required in order to then get activism that allows for the changing of constitutions. And there are an enormous number of very obvious red flags with this set of arguments. The first of which is that it is inherently retrospective. It requires judges to make enormous screw-ups on the basis of outdated laws in order to create the political will, in order to make the changes they want. So there is constantly a lag in terms of decision-making. The second problem, of course, that it creates is that not all contexts are Finland. For example, the only example that the Edge Court decided to give us in this debate was the United States, in which you need to get at least half of state legislatures, 2/3 in both the Congress and the Senate, in the House and the Senate, and the signature of the president in order to sign the bill. And crucially, in contexts in which you embed rights in constitutions, very frequently you tend to make it incredibly difficult to modify your constitution, because the idea is that they are meant to be outside of the bounds of changing by politics. So in the second instance, I think it is not even clear that this is an available option a huge amount of the time. The third thing to say is that if their case is true, and if it is true that whenever governments screw up, it is quite easy to guarantee, I'll take closing government at the conclusion of this set of responses. If it is true that it is very easy to make modifications to a national constitution on the basis of a referendum, and it is true that judges are extraordinarily out of touch, then in both worlds, there will be a relatively high number of changes to the constitution, which means the only harm that is then left is what is the precipitating event, which requires you then to look to the burden that Deepak describes, which is whether or not it is better to have judges having originalism or textualism, not whether or not it's better to have textualism or just like full democracy. So that is just a set of reasons to believe that I think that their case entirely misses the debate. Like, it is outside of the debate. It is debating a different topic. It is not sensible. It does not really count. They don't make any points that are valuable. Let's assume that they do, though, and engage with them at the absolute best. I want to begin by describing why this would be a bad idea, like why it is bad to constantly modify your constitution instead of allowing judges to do it. The first thing to say is that when you establish a norm of constant modification of constitutions, it then means that permanent changes are made in times of crisis that are extraordinarily dangerous. And if you are not yet worried by the sort of bell that I give you there, then you should be very worried by the name President Erdogan, who is now able to rule by decree, right? Like, that is to say, the weakening of the guardrails that are established in frequent modifications to constitutions that first and foremost establish the basis for participation in civic life have made it dramatically easier for him to engage in a policy of rule by decree that means that Turkish jails are about to fill up with Kurds. The second harm associated with it is that it means that your constitution fundamentally adheres the ability of wealthy people in politics to participate, right? It means it's very difficult for the legislature to ever pass any sort of law, or indeed for courts to guarantee any sort of rights to people that are poor, because now there is an automatic trump card, which is wealthy people are able to fund to an enormous degree campaigns that will hurt those people. The third thing to say is that it makes your constitution extraordinarily complex and inconsistent, which then means there are more legal ambiguities that in the individual terms in it are less effective and more able to be exploited by the most wealthy and powerful in the community who have access to good lawyers. And if you're not sure about that, then you should look to the state of California that has 4 different contradictory regulations in its state constitution that determine the way in which the top marginal tax bracket on income should be conducted, right? So it is just not a good idea. Like, even if you believe that is the debate we're having, it is bad to constantly modify your constitution. Let's talk substantively about why judges are quite good at making these decisions. But firstly, I want to talk to closing government. Do you have a POI?
Yes. So if we accept that it's really difficult to change the Constitution, do you think that there is a reason that it is so difficult to change the Constitution?
Yes, because when people write constitutions, what they're mostly writing are the rules on which societies are meant to function, and those are not meant to be subject to the whims of short-term democracies. Like, I think that is, in a traditional sense, the formal reason that is sort of provided for them. The thing that I would then say is that the values that they went about going with that task are bad. And that is the thing that we are describing to you, that those people have made those decisions in a bad way because they come from political contexts in which they do enormous amounts of damage. They come from political contexts in which they don't have sophisticated understandings. Like, for example, right, when the American Constitution was written, you literally did, there was no medical procedure known as an abortion. There was no norm known as gay marriage. And there was no concept of a gender identity that was disentangled from sex. All of those are guaranteed in the Constitution at the moment due to the reality of your due to the very, very easy mechanism of the Supreme Court reading into generalist rights, like a right to privacy, a right to equality, and then saying those things. So that is why I think that is a huge problem for that side of the House, because the values that they describe are embedded problematically. Let's talk about judges. There are a number of things that characterize them. The first is judges are better than democracies at making decisions because judges have access to a vast amount of information about the peculiarities of a particular case, which means when they're establishing precedent, they do so on the basis of much more information than a population that, even if it is well considered and legitimate, generally only has access to absolute headline news. Secondly, they're highly educated, which means their ability to perform high-functioning rational tasks is extraordinarily sophisticated. Maybe a good way to think about this is just that 50% of the population has a below-average intelligence, whereas no judge ever does, right? Which means that realistically, their ability to perform tasks of critical thinking and like value ascription are not clearly worse than the general population. The third thing to say is that they are promoted by political systems and they're selected by political systems, and they carry out laws. So they still have a deeply internalized sense they need to participate in the legal system like that. The fourth thing to say is that there are recall mechanisms if they go as like absolutely the worst. And the fifth thing to say is there are a lot of good norms about the way that the legal system ought to function that judges tend to have embodied very strongly. If you chose to become a judge, you're not a corporate lawyer, right? You're not just rent seeking. You're not a crazy person. You're someone that tends to believe in those traits. And what I think that means is that judges are actually extremely well placed to make these decisions and likely to do so very well. I want to conclude by talking about what the opening government is literally entirely unwilling to talk about, which is why originalism is a bad idea and textualism is a good idea, which is in a literal sense also the wording of the motion. Because DPAC tells you that these laws were written in contexts that were racist and homophobic and classist. And we tell you that judges, aware of modern understandings, for example, that gay marriage enjoys supermajority support in almost all Western liberal democracies, but the founders definitely would have opposed it. The same is true for abortion and things like that. We tell you that then those values are best internalized by a system of judges that guarantee that they're able to do so. It maintains the legitimacy of the system by reflecting public will while maintaining consistency of legislation and maintaining rights for minorities, which democracies themselves are not fully capable of doing. And finally, we tell you that by not forcing an incredibly complicated and confusing interpretation of the intent of these people, you then mean that the legal system is much more accessible to people who just need to make arguments on the basis of values like fairness or instead of, like doing deep historical dives into what Alexander Hamilton really thought about property law. And we think that for all of these reasons, we get a legal system that is fairer and more equal, and that is why we're very proud to oppose.
I would like to thank the speaker for that fine speech, and I welcome the member of government. Hear, hear.
Can you hear me? Great. Wait, I'm checking my time. Okay. Are we ready? Okay. I want to start with a piece of framing because I think it's important to understand what kind of cases we actually think reach the Supreme Court. Because under the current debate, it sounds like everything reaches the Supreme Court. We think it's really important to understand that the kinds of cases which reach the Supreme Court are cases that haven't been solved in lower courts, haven't reached a plea deal, and are areas that the Supreme Court considers to be of importance legally, right? We think this oftentimes means that these are important and basic questions about what our country should look like, about what our core values are, and what we believe should be reflected in the very basis of our laws. We think that the most correct document in this case, as CG point out, are constitutions, which are exactly the kind of documents that are supposed to be documents that reflect basic values. A document that says you have the freedom from religion, freedom of speech, freedom to do these different things, right? The right to bear arms in defense of the state. These are the kinds of core values that are what being an American means, right? We think that that is exactly the kind of value that we should be using in the Supreme Court, and you shouldn't be letting any Supreme Court justice decide that according to what he thinks or he wants in his own biased and non-objective fashion, we should be interpreting. And that is the comparative that OO have been suggesting so far. So, now just a couple of points of rebuttal. We think that if things are actually bad enough and loads of people are not represented, then we do have legal mechanisms that allow you to actually change the Constitution. So we think that really, if the Constitution doesn't make sense or cannot be used, then that is what is likely to happen. Secondly, we don't think it's up to side OO to decide that something is bad. The fact that most states in the US don't agree that there should be abortion is something that we think needs to be taken into account. That's what democracy is about. Saying, listen, there are loads of people, probably maybe even more than me, who disagree with what I think is right, and I have to respect them, and I have to accept what they say is part of the democratic game, and you can't just say, oh, we have issues that we think should be changed, so they should be changed. That's not how it works. In fact, tomorrow we get the an even worse thing, which we think is what we see today, where the Supreme Court judges become a power play between Senate, Congress, and Congress, and the president, between the U.S., between the Democrats and the Republicans. Where when Barack Obama tried to appoint a Democratic judge who was going to be democratically activist, the Senate refused to ratify him until Barack Obama was voted out of office. Right? They literally paralyzed the justice system in order to do this, and then once they had the power, they have elected hundreds of Republican judges who are going to put down Republican statements because they have made sure to elect activist Republicans. So we think we don't even get what side 00 want, because all that happens is that you create more disagreements and you make sure that the incentive that people have is to elect activist judges who are activists on their side, who are going to do what they think is right. So all that you're going to see, one of the biggest fears in the US, is that Roe versus Wade is going to be denied because the people who've been elected don't actually care about the objective truth, but are instead activist Republican judges. That sounds like the worst of both worlds, and we would much prefer to have somebody who tried to be impartial, as I'm going to get into it in my point, which is what judges are supposed to be, and who tries to examine the core values. Finally, we just think that they're wrong in what they think this debate is about. During the clarification that was given by the CA team, we were told that even though it is worded vaguely, guns and like obviously during the time of the Constitution, there were no rifles. We still allow people to bear arms, even though if you go word by word, it would say that you can only use muskets. We think that the point is that you're trying to interpret the meaning of what they were trying to do. So when they say you have the right to bear arms in order to defend the country because you need to have a militia to do that, you are supposed to give people the tools and the ability to do that. When you say people have the right to privacy, you are supposed to protect everyone's right to privacy because it says people, right? We think that these are the kinds of things that can actually be done. All right, so notice that, yeah, I think that's everything that's important. Oh, one last thing. We think that if you say that constitutions can constantly be changed by the judges, then we don't think the Constitution actually has any meaning anyway, and we're not clear why a judge does it better than let's get into my point. Why we think the Supreme Court should uphold rather than interpret the law. We do hear from OO the idea that it is less democratic. Why is it less democratic if judges do it? I don't really understand. They never bothered to analyze this. That's what I'm going to show you right now. We think that the idea of democracy is based on the creation of a state that represents your values and, crucially, that you have the power to change. I will take a POI from CO in a minute, so please be ready. We think that the method to achieve this is by allowing individuals to vote for their laws and representatives in order to create accountability and in order to make sure that the state actually represents what they want, while ensuring that it can actually function. As part of this, the role of judges is to exist as an impartial body that interprets the laws as they were supposed to be made of the people's representatives, just so the country can function, right? Because the law finds it very difficult to cover every single possible part of what's going to be passed, and we need to be able to literally function, and so we can have like a functioning criminal system. As a result, okay, 1 second, I'm going to get to my impacts. Do CO have an extension? No.
Do you accept that these laws were often these laws were often written with the foundation of illegitimate principles that discriminated against minorities? And if so, why is it legitimate to uphold these in the current state?
I don't think that was the case. I think that in the vast majority of cases, the ideas behind the constitutions are ideas that are global rights. That's why they're used in order to interpret that. If you look at what is essentially considered the Israeli constitution, that's the case with giving everyone freedoms. That is the case in the US constitution, where it says people will have the right to bear arms, people will have the right to privacy, people will have the freedom of speech, etc. So no, I don't accept that basic assumption in your case, and I think it's wrong. Great. Now, why do we think that activist judges are the worst? So, firstly, we think that them essentially creating new laws when they are not directly elected, not directly accountable to representatives of the people is just illegitimate. Secondly, we also think it's really dangerous. The reason that we don't let the government just pass laws and do whatever it wants is because we need to have checks and balances to ensure that there is nobody who can take control of the system. We think that when activist judges can interpret the law in whatever way they see fit and say whatever they think is true, that devoids this whole process. It means they can basically say, we think this should be the law. We don't care that the people voted in way X. They're wrong, and we decide otherwise. The jump from there to a country run by lawyers, to a country run by unelected officials is really, really short. We beg you to propose.
All right. I would like to thank the speaker for that fine speech, and I welcome the member of opposition. Hear, hear.
Okay. So firstly, we're going to mainly be talking about how this type of interpretation is important in order to ensure that the Constitution is adaptable, flexible, and relevant to modern day life and doesn't become fossilized. But first of all, just like a few extraneous pieces of rebuttal to what we heard from our CG. I think first of all, it's just like the point is, I think it's really important to look, the courts aren't supposed to be democratic. Like within our democracies, we always have institutions that are undemocratic. Why? Because we do not necessarily, I think I've already said a lot of this, but we just do not trust necessarily the population to carry out certain roles. The court is meant to be seen as a protector of liberties, but not only that, a safeguard against tyranny of the majority. Like democracy is not necessarily always a good thing. It's not something we should always look to. If we always trusted the legislature and always trusted the people, then you often do just get minorities' rights that are trampled. And we do not think that's legitimate, even if it's mainly the majority's desire to trample on minorities' rights. Just do not see that as like democratically legitimate. Democracies also have to ensure that you protect civil liberties, and that is the point of the courts. It's not there to represent the people, and it's also particularly there to act as a checks and balance against Congress. That's why they have this checks and balance system within places like the United States. Why? Because Congress itself is very vulnerable to things like the rise of populism, and when the people tend, the difference between judges and people is they are open to like being exploited through their emotions, which politicians exploit and use to their advantage. We see it as Trump. He uses very anti-establishment rhetoric and targeted the most vulnerable people in society. Said, look, only I can drain the swamp, I can do it. And what happens, you get the rise of more extreme views and populism and being elected. Those are ideologically motivated, that literally just do not care about civil liberties and rights that we still value in democracies. And that's when you lead to that erosion of civil liberties, which we see Trump already doing. Therefore, even if it is undemocratic, then we think this is perfectly justified for judges to do this. It's already within a judge's power to interpret law. It is what they do. Laws aren't necessarily even voted for in the first place, all of them. We see in that everyday life. I don't know why specifically, therefore, the Constitution has to be seen as completely democratic when you already have laws in our society that come from other sources and we do not think should be voted for by the people. So I also just secondly about I do want to challenge just how democratic these laws currently are. When they were written hundreds of years ago, I think the intent of these founding fathers is invalid, to the point in which they lacked knowledge about the future when they wrote this. They lacked knowledge about the attitudes of modern day. Therefore, I still don't see why these are so valid when they lack all their information to be able to make decisions about what future democracies want. And the point at which it is tied to if people are tied to it, I do not see that as democratic either. Because also the point is not just that amendment processes are difficult, but sometimes they are literally just impossible, especially within the US, because the founding fathers just did not see future problems. An example of this is when the founding fathers wrote the amendment process, there weren't things like political parties, there weren't things such as factionalism. Therefore, things like supermajorities just weren't as impossible to reach. Under the current climate where you have massive party polarization, a 2/3 majority in Congress and a 3/4 ratification in states is just physically impossible under the status quo. Therefore, when there is like intrinsic flaws in the Constitution and in the amendment process specifically, then we just literally cannot rely on that to begin with. And that's why we cannot always necessarily trust the word of the founding forefathers and take it as this democratic legitimacy, because they do not necessarily understand the current political climate when they wrote it, and therefore did not foresee challenges that make such things impossible. Therefore, why do you think it is very important in order to be able to interpret these laws, in order when amendment processes are not only very difficult, but in some cases impossible, it is very important to therefore allow this Constitution to be flexible and to be able to be adapted to modern day society when you can't rely on amendment process to begin with. And it's important to note that this flexibility is not entirely unrestrained. Like the judges are still constrained to the words of the Constitution. And in some cases, this is quite objective. For example, is the Fifth Amendment in America, the right to remain silent. That is a very uncontroversial law. It's not something that judges can suddenly turn up because they decide that they are maybe really right-wing and think that we should try and take a more hard line on like prisoners. It's just not physically possible using those wordings. Therefore, these interpretations are only applicable in cases where they are very ambiguous, the wording. Why is this? Probably just because the language used is very ambiguous, which means it's just very difficult to determine. Or secondly, it's probably just difficult to apply to modern day scenarios. So, for example, the bear arms situation that was used in order to armor people at a time when their own governments was very repressive. Times of like they just come out of a civil war with George V, and they saw their own governments as very repressive. Therefore, when they no longer have those values in life, they're very difficult to apply to scenarios. So I think instead judges are left with two options. They should either find the original intent, as with Originalists, or I think the second option is they should just locate the values and therefore reapply that. And I think so I think the question they need to ask is, what values do you want to entrench? Because values, again, are not constant, they do change. Doesn't necessarily mean it is undemocratic and you are steering from it entirely, but it's still important to apply the values to modern scenarios. An example of this is the 14th Amendment. Go on then, Stevie, I'll take a question now. No? Okay, I'll carry on.
Yep.
Okay.
Your best case scenario is judges being elected for them being activists by Republicans or Democrats, rather than actually acting as the impartial interpreters that you want. This is doubly true about the most important issues, like abortion, like freedom of speech.
Okay, I admit that the courts have become politicized to some degree. However, I just think on the comparative, courts are always going to be less politicized than Congress. Why? Because even when they are elected by a Republican, by a Democrat, they have no loyalty to that party afterwards. They are free to change their mind. They can follow whatever thing they want. They're not tied to an ideology, and they're far more likely to have those. They don't have to care about getting re-elected. Therefore, I think the problem, therefore, is that. So like the right to privacy, you literally just cannot apply that to modern day scenarios such as abortion. You have to, and you suddenly limit it and make it very difficult to apply. I think the problem is that just means many parts of the Constitution just become very fossilized and outdated. And when laws become outdated, they just become void. I think this massively erodes the Constitution's authority, where people just cannot rely on it anymore to protect their civil rights, because they just cannot be applied to everyday scenarios anymore. This means that you massively reduce the agency for minorities to even go to the Supreme Courts in the first place and try have them to protect their civil liberties, because parts of these constitutions are just so outdated and so fossilized, they just cannot be applied to everyday life. You can't try seek rights to privacy when maybe the specific niches you're doing in terms of abortion just weren't applicable back when the 14th Amendment was being applied. And even though the value is still valid and you still think you are entitled to certain privileges through the value of privacy, if you use an originalist intent, then you just cannot rely on that, and therefore you erode the Constitution and its ability to protect minorities. All these reasons, proud to oppose.
I would like to thank the speaker for that fine speech, and I welcome the proposition with. Hear, hear.
Can you hear me? Yay. I think the entire opposition bench has two underlying assumptions that they never explain or analyze to us, which just put a lot of their cases out of the debate. I think their first assumption is that the judges that are going to be standing, the justices in the Supreme Court, are going to be reflecting those values that they want to uphold and that they think are modern contemporary values, which, as we have shown you in today's process, is not necessarily true, because the president, specifically when they are allowed to interpret, the people choosing those justices are going to lean towards choosing justices which will interpret things in the way they believe in. If it just so happens that the people choosing those justices are choosing justices that are on the same side that oppositions are in cases of modern values, then maybe that happens. In the cases that those people choosing the justices aren't on the side of the modern values that opposition wants, we get interpretations in exactly the opposite way. I think opposition bends completely ignores the fact that justices don't necessarily agree with them, and therefore we don't necessarily get the modern change and modern view on laws that they want. I think opposition's bench's second assumption here is that those modern values are, for some reason, the objective, correct, and right values that we want to instill in society. We do not think that it is the job of laws or the role of laws to instill new values and to tell society what the values it should have are. We think that the only role of the democratic government and the democratic process of checks and balances is to reflect in the best possible way what the people want and what the people believe in. We think that the farther away you get from that, the worse it is. I have two clashes in this debate. When should change happen, and how change will actually happen under both sides of this debate? I first have two very small points of external rebuttal to CO. They tell us that democracy is not always a good thing and that we need to ensure and protect civil liberties. We think that ensuring and protecting civil liberties is a part of the democratic process and part of the things that are in the law and things that you need to uphold. The thing that is preventing legislation from putting forward laws that are against minorities and specifically racist is the fact that in the Constitution it says that we all have equality and equal rights. We think that once you get to interpret that however you want, one day you will get a justice who thinks that that is only applicable to men for some reason, and that is when we get the opportunity to be undemocratic. And then she talks to us about the process of checks and balances. We would like to remind CO that the process of checks and balances puts checks on the Supreme Court as well, and puts checks and balances for the Supreme Court as well, so that their power strictly doesn't go overboard into what they are meant to do. And what they are meant to do is only uphold those laws and reflect those laws that have been put forward by people who are directly representative of the population. Let's talk about when change should happen. Look, we think that in First House basically assumes that change should happen and talk about how that happens. OO say that modern values should be reflected without explaining why what they think that modern values are right and why they are in consensus. They give us the example that we all believe that people today mean all sorts of things, right? But I would like to point out that that example falls on our side of the debate, because when you can interpret what arms means, then you can interpret that it only meant muskets, right? When you can't interpret what that means, you have to go literally by what the word says, which is what allows us to have which was what allows people to bear every arms today in the United States. So we think that falls on our side of the debate, because when you are not allowed to interpret what the word means, when the word people means people and you can't interpret that, that falls on our side of the debate, even by their example of what they want, right? And they just don't explain why the values that they specifically are interested in are the values that should be reflected. OG say the words democratically and why it's important that we have democratic process without explaining what that means and why it's so important. What Yishai shows you is we're the ones that explain why the difficulty exists, why we need a consensus to change the core values about the society, which is what the Constitution reflects, and why specifically in cases that reach the Supreme Court, what is in question is the underlying values of our society, and why the underlying values of our society, specifically it is important that we reflect the society and not the interpretation of a specific of a specific justice. We think that with so much at stake, it is not up to judges to tell people what those values are. That is why we are the ones who explain why specifically in these cases, the democratic process and reflecting societal values is what is so important. And that is what justifies going through all of the difficulty and complications of changing constitutional law today. It should be difficult because the changes it is should reflect an entire society and what an entire society is about. We are the ones that justify that, and that is why we win that clash. Second of all, how that change happens and what kind of change happens. Look, I already pointed out that oppositions just assume that the changes they want to happen will happen in terms of modern interpretation. We think that OG answer this by saying that judges are old and therefore they are going to interpret things in an old way and not reflect modern values. We think that that is not the heart of the issue. The heart of the issue is that on these issues, people don't necessarily agree on what those modern values are. And definitely judges themselves, who are also going to stand to either side of a political map, may interpret it in a way that is not only not the way opposition wanted, but not the way the people wanted. And that is a problem. Before I continue, I will take opening.
Look, I did give you 5 reasons in my space that judges would be sufficiently contemplative, but what Deepak and I both explained is that although our values may not be objectively morally perfect, they're a hell of a lot better than what you guys need to defend, which is like, you know, scripturalism that is based on the words of long dead racists.
Thank you. Thank you. I don't think that's true. What we need to defend is going through the difficulty and complications that exist today in changing constitutional law. Do we think that means it is more difficult and harder to change? And yes. Do we think that it is justifiably so? Also yes, because the things at stake are so big. The assumptions are so big, and we need to make sure they actually reflect the changing values of society and do not reflect the values by the justices. Yishai also explains to you that this is exacerbated, is a word, that by the fact that the president and that the government chooses the people and how he chooses those people today. When he knows that judges can interpret and change things, then people who are radically on one side of a political map will choose justices that will interpret things to that side of the political map, whether it is the side that opposition want or not. We think that on the flip side of that, when people can know that the judges can't interpret, then they will choose the people who are most objective. And therefore we uphold the societal values that exist today, because we are the ones who show you when change needs to happen and why that happens in times when it's not needed, when justices can interpret. We are the ones who win this debate.
I'd like to thank the speaker for that fine speech, and I welcome the opposition whip to close the debate. Hear, hear.
Okay, so I'm going to do a team by team here, looking at why we beat, first of all, OG, then CG, and finally OO. Let's go through them then. First of all, let's talk about OG a bit, right? Because OG brings us a case about how they prefer amendments to interpretation, because they see amendments as a more democratic way of changing the constitution that's closer to the will of the people. Two main flaws with their case, right? First of all, they fail to prove that mutual exclusivity. This is really important in that they don't show why it's the case that you can't have both reinterpretations and amendments. We're not told anything regarding this, aside from the idea that you've got more incentive to amend the constitution when bad things are happening, because judges are interpreting the constitution in an originalist way, which then forces you to amend the constitution directly. Two problems with this idea, right? First of all, it requires bad things to happen first in order to achieve these amendments later on, because to provide the government with this incentive to change the constitution, they require judges to be making poor choices by interpreting the constitution in an originalist manner. They then encounter the problem with any accelerationist argument, which is they are requiring bad things to happen first. They are entirely dependent on these negative consequences occurring in the first place. Second of all, is that if it is possible to amend the constitution relatively easily, as they suggest it is, and this is a better mechanism for changing the constitution than interpretation, then why can't the judge simply interpret the constitution in their own manner and then continue to support a change in the law as well and suggest that as well? Again, we're really unclear as to why it's not the case that both of these things can occur, because they fail to prove that. We think they fall out of the debate. Second reason that they fall out of the debate is that they don't actually give us a mechanism or a reason as to why democracy is such an important feature to have in this kind of system, in that we're not really given any reason by OO as to why we specifically by OG, as to why we specifically need democracy in the Supreme Courts, as opposed to having a check and a balance as well. So because we're not really unclear about the importance of their case, we don't know where it falls in the debate, and as such we think that they fall out for this reason too, particularly when we compare this to what Georgia tells you, when we tell you that we value some consistent kinds of checks and balances that have to be outside the ever-changing system of democracy and outside the government and the parliament in order to be able to determine what's happening. Additionally, so because we provide a reason as to why we think democracy is not important, they don't provide a reason as to why it is. We think we necessarily have to take it over them and they fall out of the debate. Let's talk then about CG rights, because CG brings us a couple new things. They essentially tell us about how it's important to interpret the original meanings of the Constitution. This is a really beneficial thing to do. First thing to note is that their entire case is a massive knife for their opening half, right? And the OG agrees with both of the opposition teams that these laws shouldn't be maintained, and that in either way, the Constitution has to be changed in some manner. The only difference is that OG suggests this happens by amendments, we suggest it happens by interpretation. So when CG comes in and bases their entire case on these on the original Constitution being a positive thing and the original intent being positive, it's a massive knife of everything that the opening half stands for. And we think that they fall out of the debate for that alone. Even if that's not the case, however, here's why we beat them anyway. Because first of all, they tell us that it's important to use these original meanings, and in response to my point of information, he says that these are non-discriminatory measures, that they are positive measures that value equal rights for all. First of all, we tell you just by examples, this isn't the case. The US assigned members to the House of Representatives based on the population of each state, considering a black person to have 2/3 the value of a white person. They didn't give women the vote until the 19th Amendment to the Constitution. So it's incredibly naive to say that the intention of the original forefathers of all these countries were to have equal rights for all, because equal rights for all weren't even considered like feasible back when all of these countries were created in the first place. It was unthinkable to have like homosexuality be like even legal, let alone have like gay marriage be legal and equal rights in the workplace and various other things that we have now. But second of all, we think that like their intent can't be valid anyway, because intent is dependent on knowledge, right? You need to have information to be able to make a decision that's the basis of informed consent. So we think that like to be able to create a law, you need to have a knowledge of like this situation in which that law will take place. The Forefathers didn't have that, and thus we think that invalidates their choices. As to why we think this is different from other normal laws, because we follow like other laws that were written hundreds of years ago. Anyway, we think the difference between those and the Constitution is that it's far easier to change other laws. So the consistent choice to not change like a regular law that was established 100 years ago means that it has some kind of legitimacy, right? Because you're continuing to choose not to change it. The difference is that given that changing a constitutional law often requires like a supermajority or something above a majority, it's like far harder to change it, and as such we don't think it maintains that legitimacy because there's no continued choice to keep it. You're often forced to keep it even if it's against your will, so we don't think it can be considered legitimate in the present day. They then give you this thing about how like activist judges are bad. Again, we tell you that like activist judges can have minimal harm simply because they can't like do a whole lot. They're still bound to like the wording of the Constitution, right? But like additionally we think that like interpreting the original intent of the Constitution is also a subjective measure, right? There's subjectivity on both sides, but also they entirely ignore OG's comparative, and the OG tells you that the choice is between courts and Congress, and that's what this debate's about. So when CG comes and tries to frame this as like there's an alternative, which is nothing happens, either way, we think it's like really bizarre. If we go with OG's comparative, courts are obviously far more, Congress is obviously far more politicized than the courts are, so all their harms apply more so under their side. Their entire case is a knife and contradictory to OG. They can't coexist. Possibly they fall out the debate as well. In terms of our case then, how it stacks up against OO, first of all, let's ensure it still stands by defending it against the attacks that CO brings. We think that like CO tells you, first of all, the Constitution is what protects us from harms to minorities and not like enforces those harms. We like tell you, first of all, we don't think this is the case because of the reasons I've already given it, and that like constitutions originally don't give everyone equal rights. It's a massive assertion that they make that's proven entirely false. But we think that like even if they do, then they say equality for all. Note that like you can't interpret equality for all to mean equality for everyone except a certain number of people, unless you are interpreting the original intent. Just the original intent of these forefathers means equality for all like straight white males, right? We think that like that's the point at which your intent kicks in to be against minorities. When they talk about checks and balances being needed as well, those checks and balances are the words of the Constitution. You are still bound to those words. You are just bound to those words without the original, often like racist, misogynist intent of the forefathers. What we give you then is this case about like why fossilization is like an incredibly negative thing, and in the same way that when regular laws aren't used, they become void. The fact that like because these measures can't apply to the Constitution, because the Constitution is bound to a different set of like checks and balances than other laws, we think we need an additional set of checks and balances on the Constitution itself. The Constitution has to be the same, and the way we do that is by enabling the Supreme Court to apply the current intent to the Constitution. We think like we need to have these measures simply because the current measures that we have can't apply to the Constitution. This is why we oppose. Thank you.
I would like to thank the speaker for that fine speech. Thank you all for a very good debate. Please go away. If you want to find me or any of the judges for feedback afterwards, please do. Bye. After the break. Are we off stream yet?
Yeah, that's what I wanted to ask, if the stream is still here.
Yeah, let's not say anything until we know.
Sure.